Back to Delphi. Judge Gull still on the case. Baldwin and Rozzi are back on the case as well. However, the speedy trial request, well, nope, that's not going to happen, according to the Indiana Supreme Court. But like I said, Baldwin and Rozzi are back. Judge Gull is going to stay. One out of the three motions, I guess, ain't bad. Two
Yeah.
out of three. That was one out of three, so it's not quite the Meatloaf song. Joining me to discuss, Bob Motta, defense attorney, host of the podcast Defense Diaries. Probably not surprised by what went down and what was granted, but here we go again. We got Baldwin and Rozzi back, and Judge Gull pretty much immediately back at it, saying that Frank's hearing that we were like about to literally have, like people are here for it, and then I'm going to dismiss all of you. We're not going to do that anymore because I didn't want to have it in the first place. That's why I got rid of you. Didn't say that, but yeah. So are you surprised? Because this just seems like we continue to go and we're not de-escalating the insanity here. It just keeps going up with Judge Gull.
Yeah. No, I'm not surprised by the way it went down. I thought that they'd get back on. I thought that they would keep her on, and I thought the 70-day trial date was of no import to the Supreme Court because they can still file their speedy
Mhm.
demand. They have the ability to do that themselves. So the court didn't really need to address it. In terms of what she decided to do 2 business days after the Supreme Court basically said, and without there being an opinion yet, like
Mhm.
that's the one thing that we need people to understand is that they put that order out in unbelievably fast, fashion in terms of it came out the same day that the hearing took place, reinstating those 2 guys. And they said, but our opinion's coming, and that
Mhm.
opinion is very important because it's going to give all of us, and more importantly, the attorneys on the case, the understanding of what their rationale was with respect to why they made the decision. Because there was at least one judge that dissented. It could have been a 3-2 count, it could have been a 4-1 count. We don't know. My wife tends to believe, and I agree with her, that the most likely reason for the dissent was the fact that they had not necessarily argued with what we thought that they should have, Allison and I, which was that they had entered their pro bono appearance, that they were no longer appointed counsel, but that they were in fact counsel of choice by way of them entering that appearance. And they didn't really include that in their petition.
Mhm.
So it was left with the fact that, okay, continuity of counsel, they were appointed attorneys. We think that, Gull just didn't follow due process. It wasn't done properly. There should have been a hearing. And that the bottom line is that one of the judges may have taken exception with the fact that they should be reappointed
Mhm.
as so they're getting paid by the county as opposed to, they should be on as pro bono where they're
Mhm.
not getting paid,
Yeah.
because that was the part of that structural error argument. uh, if that was taken at its face, would have existed if, in fact, the court would have looked at it and said, okay, well, we do consider them to have entered their private appearance as private counsel, which then takes it out of that whole "you've been appointed" thing, because the case law there is not as strong. It's very murky with respect to whether or not Gull can just remove them. Once it becomes, hey, we're entering our appearance pro bono. We've given you the evidence that Richard Allen wants us as his attorneys. It changes the completely the analysis in terms of the Supreme Court
Mhm.
because of that Gonzalez case, and it basically says, look, this is private counsel. She can't remove them. If it is, it's structural error, which means you're going to have to retry the case automatically.
Yeah.
So she tends to think that that's probably the reason, and I think that that probably is the reason for the dissent. There was probably a judge there saying, no, they should have brought that, because that's what the record shows happened,
Mhm.
and they're just trying to get paid on it. And I don't think that under the law that's an available option for them, because I,
Mhm.
I think that they were appointed counsel, and
Yeah.
I'm not buying the continuity argument. So it shocked me that she decided to do what she did. Um, like I said, 2 business days after the order came down, without the opinion being out there, and the Supreme Court very clearly stating that this record that you've created, Judge Gull, sucks.
Hmm.
You know, like we have no record. There is like this record is devoid of any substance, and for her to do it again,
Yeah.
because when she goes ahead and denies not just the Franks hearing, but the motion to suppress as well as the motion to eliminate for the ballistics, she denied all three of them in a summary fashion, giving no real rationale as to why, citing no case law at all, in a summary opinion on three major motions. Like all she's doing is doing the exact same thing that the Supreme Court literally just admonished her for doing during
Oh,
the entirety of the case. It was like it
why?
was incredibly befuddling to me.
Yeah,
And
because
and my I
why?
think why she did
Yeah.
it, this is my because she knows they're going to re-up their motion to recuse her.
Hmm.
And I think she was trying to beat them because once that happens, once they file the motion for her to be removed or recusal, she has no ability to rule on substantive motions until that's dealt with.
Oh.
So I think she was trying to beat them to the punch
Hmm.
because she anticipated that thing coming down any day.
Hmm.
And she's like, well, before you do, I'm going to deny all your motions. But there's like to me, there's still the argument that Rosie had filed one.
Hmm.
He had already filed a recusal motion the same day that he had filed his verification that he was still Richard Allen's counsel, which
Yeah.
was after the 19th and before the 31st. So it happened in between. So like it's a real gray area as to whether or not Rosie had actually withdrawn. He had made representations that he was going to, which I guess you could argue both sides of it. Is that enough to consider him to be withdrawn? If you're looking at the statute in Indiana, no, it's not even close. I mean, it requires that the defendant be given, notice in writing, and like there's a whole process for it. It's not just like, okay, I'm withdrawing, and the defendant was never, ever present on the 19th in front of the judge on the record where she's admonishing him saying, look, you now don't have attorneys. I'm going to appoint new attorneys for you. You know what I mean? So
Yeah.
that didn't happen. So, but there is a valid argument, which would basically mean if if Rosie's first recusal motion was found to be valid in terms of she would have been foreclosed from making those rulings anyway,
Hmm.
which wouldn't stop her from down the road just making the same rulings again. Because the way it's going to go in Indiana, and I had the discussions with a lot of Indiana attorneys when I was at the hearing, is that she's going to sit on her own recusal hearing. You know
Hmm.
what I mean? It's not going to be an independent judge. It's going to be her deciding whether or not she's biased.
How? I mean, yeah. I mean that isn't that just a prime example of a major error in our system? If that's how that
I
works.
mean, dude, don't get me started. I don't know. Like I
Yeah.
was sitting there, I was like, really? Really? I was talking I had like 3 or
Yeah.
4 Indiana attorneys with me, and I'm like, "You're kidding me, right?" I'm like, I could see on a conflict, like, because they do the same thing here in
Yeah.
Illinois. Like, a judge will handle their own recusal if it's an issue of a conflict or a
Yeah.
potential conflict, 'cause they'll typically say yeah or no.
And do the
Yeah,
right
no,
thing.
I have a
Yeah.
conflict. Yeah. But when it comes to bias, I mean, how are you having the judge who you're accusing of being biased ruling on their own? You think they're gonna admit, "Yeah, I'm biased." They're not gonna do that, like,
No.
ever. I can't imagine a scenario in which like, I keep hoping that when they file it, she's just gonna say, "You know what? Like, with my new appointment as
Yeah.
chief judge,
I mean,
I
enough is enough. I mean, she seems to have ambitions to go to the Supreme Court. Is this am I missing some of the tea leaves here? Is there some part of this by acting this way that's going to help her get there? That's just a selfish way of acting, or is this just 100% ego?
I can't think that anything that she's doing now is helping her bid."
Yeah.
You know what I mean? Like, to get to the Supreme Court.
Yeah.
It's like everything that she continues to do in this has to be seen as a detriment to her bid to move up to the high court.
Yeah.
Like, I just don't know how she's thinking that she's helping herself with these kind of things that she's doing. It's just it's bizarre, man.
Yeah.
Like, I wish I could crawl into her brain and figure out what she's thinking, or like, is she taking advice from somebody who's given her really bad advice? Like, I just don't know, because it's like there's no part of me that thinks that she's in cahoots with McClellan. I mean, it's not even her county.
Yeah.
She doesn't know Nick McClellan from a hole in the ground. You know what I mean? This is all her independently handling these issues. But man, she's making the wrong choice, like left and right, in the terms of how she's handling this case. And to me, when she did that, just like basically spitting in the face of the Supreme Court saying, your record is a shambles. And then
Mhm.
just doing it again, like doubling and tripling and
Yeah.
quadrupling down by denying three really big motions, which look, if they're litigated, she may have found all of them to be
Sure.
denied
But at
based
least
on
hear
the
him.
fact that she didn't think there was enough, but at least hear them make a record.
Yeah.
Let the attorneys argue it. Let there be some case law cited. Let the proper standard be applied. Like she applied the wrong standard in terms of her denial on the Franks,
Yeah.
like flat out. Which just goes to show that she's flying from the hip, man,
Yeah.
and it's reckless
Yeah.
on too big of a case with too many eyes on it. So I don't know.
Hey, it's Tony Bruschi. If you like the podcast, be sure to like, subscribe, and press that bell so you don't miss any of our updates on the cases we're following for you right here at the Hidden Killers podcast from True Crime Today. And thanks